Hi, and welcome back. Today we take up one of my favorite topics, which is negligence. Negligence is the law of unintentional, non-criminal wrongdoing. Negligence plays a huge role in our society. It, of course, provides for compensation to those who are injured by the negligent acts of another, but it also serves an important regulatory role, and that's what we'll be talking about today. So, tort law, the law of torts, the law of non-criminal wrongdoing, provides a great deal of regulation in our society. And so the law of negligence plays a huge role in our life, whether we know it or not. And so because of its importance, the law of negligence requires special scrutiny. And that's why we're spending time on it in this class. So today we're going to examine negligence law and the elements of a negligence claim. Now, negligence is the failure to exercise reasonable care to avoid injury to another. A negligent party fails to do that which a reasonable person would do under the same or similar circumstances. So negligence law protects individuals against harmful acts of other members of society, even when those harmful acts are not crimes. They don't violate a criminal code, but they are still wrongful acts. Now, negligence requires no intent on the part of the tortfeasor. A tortfeasor is the person who commits a tort. And negligence does not require any intent on their part. And this is one of the ways that the law of negligence differs greatly from criminal law, which requires intent. But in the law of negligence, one can commit a wrongful act completely on accident. So negligence may include liability for an action, but it could also include a liability for failure to act. Now, negligence, the concept, the legal doctrine, is composed of 5 elements. So to understand whether a party has acted negligently or not, whether they have violated the law of negligence, we need to look at these 5 elements to see if they are present in the situation. Starting with the defendant had a duty of care. Now, we're going to explain all of this in a bit more detail, but right now, just understand that a defendant, the person who's being sued, the one who's being alleged as a tortfeasor, must have owed a duty of care to the individual that was harmed. You must establish that the defendant breached that duty of care, meaning they did not follow through on their legal responsibilities toward the person that was harmed. Furthermore, you must show the defendant's conduct was a cause in fact of the plaintiff's injuries. Now, when we talk about cause in fact, we are often referring to this as but-for causation, meaning but for the defendant's acts, the harm would not have occurred. So it must be a cause in fact. The 4th element is a little harder to explain, and we will get there in a minute, but essentially this requires proximate cause. And proximate cause means there must be some relationship between the harm that was suffered and the causation effect. Again, proximate cause means there must be some close connection between the breach of the duty of care and the harm that was suffered. And again, we'll try to explain that in a bit more detail. And finally, the plaintiff suffered damages. And these must be actual damages. There must have been some loss recorded as a result of the tortfeasor, the defendant's wrongful act. So let's look at all of those in more detail, starting with a duty of care. Now, a duty of care is simply a legal obligation to act reasonably. And a person is under a duty of care to all others for their physical safety or property, which is to say, for every act that you do, whether it's driving the car, whether it's crossing the road, whether it is publishing a newspaper. For every act that you do, there is a scope of people who might be injured by that act. So if you're driving a car, then that scope would extend to everyone in your immediate vicinity. You owe a duty of care. You owe a duty of care not to speed. You owe a duty of care to maintain control of your vehicle. So those are in part crime, but the law of negligence also says you have a duty to act reasonably. And this duty extends to everyone who it is foreseeable may be harmed by your act. So in driving a car, the duty of care extends to all the cars around you. It extends to any pedestrians you might encounter. It extends to any scooter riders that you may encounter. There is a duty of care that you owe simply because you are committing this act. You are driving this vehicle. Now, duty of care arises in 3 different situations, and I've already told you about the first one. If the victim was among those who would be at risk, was foreseeably be at risk of harm from the actor's conduct, then you owe a duty of care to them. So again, imagine an act, driving a car for instance, and imagine a scope around that of everyone who may be injured by your driving of the car. Well, you owe a duty of care to all of those in that circle. A duty of care could also exist if there's some sort of a relationship between the defendant and the plaintiff, some sort of special relationship. So, for instance, an accountant owes a duty of care to those that he is preparing tax returns for, right? There's a duty of care owed there. A landlord owes a duty of care to their tenant. Whoever, because of this relationship, landlord-tenant, the landlord owes a duty of care to that tenant. And finally, a duty of care exists if there is a statute or regulation that provides for one. If there's a specific legal reference, injunction, then a duty of care can exist. Now, you do not owe a duty of care to the world as a whole, and you have no duty to engage in rescue. Generally, there's not a duty to rescue someone who is in danger. Even if you have special training, if you are a trained, certified lifeguard and you are walking by a neighborhood swimming pool and you see someone drowning and you're late for class and you decide to pass on saving someone, instead going to class, well, you did not owe a duty of care to that person. That person was not in that scope of the duty of you walking to class, a person who might be injured. Now, if you assume a duty, if you do make an effort to go out and rescue this person who is drowning in the swimming pool, then you now have a duty of care to do what a lifeguard would do in the same or similar circumstances. What would a reasonable lifeguard do in that situation? You are bound by that duty of care. So that's duty of care. That explains to whom we owe a duty. Now the next concept is breach of the duty of care. And breach occurs if the defendant failed to do what a reasonable person would do in those same or similar circumstances. So if the defendant failed to act reasonably, then it creates a breach of the duty of care. Now, how do we know whether someone has acted reasonably or not? What does that mean? It is the reasonable person standard that establishes the standard of care, meaning once we prove that you owe a duty, how do we prove breach? Well, we have to show that you acted in a way that was similar to what a reasonable person would do under those circumstances. So the reasonable person standard says that a party must act as a reasonably prudent person would under the same or similar circumstances. A plaintiff in a negligence case, someone who brings a claim against the defendant, must prove that the defendant did not act as a reasonable person would have. So if you are involved in an auto accident and you are hit from the rear by a person driving behind you, this person behind you owed you a duty of care, right? We said that you're in that scope of the duty. You were driving in front of him. And when they failed to stop in time, then they breached the duty of care. A reasonable person would maintain sufficient distance to allow themselves to stop in the case of an emergency. The person behind you did not. So you would argue that that party breached the duty of care. If you sued them, the defendant would have to prove that they did what a reasonable person would do under those circumstances. Now, there are other aspects of breach, and we'll touch on them briefly. Not going to go into too much detail. One is called negligence per se. Negligence per se occurs when there has been a violation of a safety statute, meaning some law or some regulation that was enacted for safety reasons. One could argue that you, in breaking the law, committed negligence per se. So if you violated some safety statute, that's enough to show breach of a duty of care. We don't need to go to the reasonable person standard. What would a reasonable person do? Because the duty of care was established by the safety statute. And if you violated the statute, then you breach the duty of care. Another concept is called res ipsa loquitur. This is a Latin phrase which means the thing speaks for itself. In these cases, we can infer the breach of a duty of care. We can infer that there was negligence simply because of the circumstances. So we don't need special expert witnesses to come in and tell us whether you acted reasonably or not if it is obvious from the circumstances. So, for instance, if you go into the hospital and you are going to be having your left knee replaced, you're going through a knee replacement surgery. Well, if the doctor operates on your right knee instead of your left knee, we don't need experts to tell us that that was a breach of the duty of care. We know it, we can infer it from the circumstances. And if you've ever gone in for some surgical procedure, you'll notice that one of the things they always do is to draw exactly on the part that's going to experience the operation. Why? So that there are no mistakes. So that's breach of the duty of care, and that's part way to proving a negligence case. Now we come to causation. And there are two aspects of causation. Basically, what we're talking about when it comes to causation is that the breach of the duty of care must have caused the injury. It's not enough that there was a breach of a duty of care, but that breach of the duty of care must have caused the injury. Causation is composed of two elements. One is to prove actual cause, known as cause in fact, and the other is to prove legal cause, which is known as proximate cause. So actual cause, cause in fact, that is the but-for causation that we were discussing. But for this act, the incident would not have happened. So cause in fact is an act or an omission without which the plaintiff's injury would not have occurred. So in the situation of you're driving a vehicle and you are struck from the rear, that breach of the duty of care, that failing to maintain a proper distance, caused the accident, right? So there's a link between the breach and the harm that was suffered. And we call that cause in fact, meaning the accident would not have happened but for your failing to maintain the distance. So cause in fact is an act without which the plaintiff's injury would not have occurred. Now, two parties can both be the cause in fact of an injury. If if you live in a house and the neighbor on your right side is burning leaves in their backyard, and that fire spreads to your house, then they have breached a duty of care that they owed to you, and that breach of the duty of care caused harm to your house. But if at the same time the neighbor on the left of you is also burning leaves in the backyard, and it also causes a fire, well, you could sue either party as the cause and fact of the injury because your house would have suffered regardless. Don't spend a lot of time thinking about that. It's just something that we throw in there. Now, causation can also be established if the act is a substantial factor. And again, I don't want to spend too much time on that. When you think of cause and fact, you look to see, would this incident have occurred without the breach of the duty of care? And if it had nothing to do with the duty of care, if there was a breach of the duty of care, but that didn't cause the accident, then there is no cause in fact. The second aspect of causation is what we call proximate cause. And proximate cause requires that the negligent act be closely related to the injury. So the question that a jury will ask, or what you would ask if you were analyzing a case to see if there was negligence or not, is there a close relationship between the cause and the harm? And the most important factor in determining proximate cause is foreseeability. Is it likely, is it foreseeable that this person would have been harmed by the type of act that constituted a breach of the duty of care? If the harm is not foreseeable, there is no proximate cause. Proximate cause is a very complicated relationship, a complicated concept, and to illustrate that, this is the classic case. If you go to law school, you will undoubtedly see this case. If you hear anyone discussing negligence, you will hear about this case. It's a classic case. It involved a person, Ms. Palsgraf, who was waiting for a train. She was standing on the platform waiting for the train. Now there's another train going by, and there is a man desperately running to catch the train. The train has already started to move, and there's a man running to get onto the train, to catch up with the train. One of the conductors on the train, one of the porters, just trying to be helpful, helps the man and pulls him into the moving train. Now there's a rule against this. The railroad has a rule: you should not try to assist a person running to catch a train. Nevertheless, the porter helps the person onto the train, helps the man on the train. At the same time, and this is where it kind of gets odd, the person running to catch the train is carrying a package. And when he is pulled onto the train, the package drops onto the tracks. The package contains fireworks. when the fireworks hit the hot track, they explode violently. Miss Palsgraf, remember, she's there waiting on another train. She's waiting on another train. Miss Palsgraf is standing underneath a heavy iron scale that's used to weigh things, to weigh cargo before it's placed on the train. The explosion caused by the fireworks causes the scales to vibrate loose, and they fall and they strike poor Miss Palsgraf on the head, and she is injured. Palsgraf brings a claim for negligence, and the breach of the duty of care is easily established, right? There was the person running who was assisted onto the train. There's a rule against that. The railroad has a rule against that. So, duty of care and breach. Now, cause in fact is also established, right? Had the train porter never pulled the man onto the train, the man would not have dropped the firework package. The firework package would not have exploded. The scales would not have fallen and struck poor Miss Palsgraf in the head. So we have duty of care. We have a breach of the duty of care. We have cause and fact, right? It happened because of, it was a but-for cause of the accident. But there's not a close relationship. What was the purpose of that rule? Well, the purpose of the rule was really not to injure anybody as you pull them onto the train, not to cause harm in that fashion. So that was the reason for the rule. It was not foreseeable that a person being pulled onto a train would be carrying explosives, the explosives that would fall and would cause the iron scales to lose their grip and to fall. So essentially, when we're talking about proximate cause, there must be some close link between the thing that was wrong and the harm that was suffered. It's not enough that we simply establish cause and fact. We have to break that chain of events at some point, and we call that proximate cause. Finally, damages. A plaintiff has to suffer actual damages. They must prove that there was some harm, physical harm, and there were some resulting losses in order to recover. Physical harm does not always mean that, you got a broken leg or something. That there is mental harm that could also be a loss, could also constitute actual damages. Damage is usually easy to spot, to determine whether it's there or not. Simply look at the problem or look at your situation, and did this person suffer damages? There are defenses to negligence. So a defendant who has been sued can either avoid liability or at least reduce its liability. And there are certain doctrines that allow this to happen. The first is called contributory negligence. Now, contributory negligence is an old doctrine, and it has been eliminated in virtually every state. There are only 4 states that maintain the contributory negligence defense. And what the contributory negligence defense says, that if the plaintiff was negligent themselves in any way, then they cannot recover. They simply cannot recover. If the plaintiff did anything wrong, then they don't recover. So if you have a situation where someone is crossing the street and there's someone coming the opposite way, and that person coming the opposite way is intoxicated and overly tired, and runs a red light and strikes the person, that's negligence, right? Now, the law of contributory negligence says Well, if that person was not crossing in the crosswalk, which is what was required, then that person recovers nothing. So it was a very dramatic defense, and it caused a huge number of problems. And I mean, it's kind of astounding that it still exists in 4 states. Now, virtually every other state has adopted what's called comparative negligence. And comparative negligence apportions the damages based on fault, meaning a jury will determine how much of the accident was the cause of the defendant and how much of the accident was the cause of the plaintiff. And then the damages will be reduced for the plaintiff by its percentage of negligence. So if the jury determines that the defendant is 75% at fault and the plaintiff is 25% at fault, that means the plaintiff can recover its damages subject to a reduction by 25%. They can recover 75% of their damages. So the jury determines fault, and then the jury determines damages, and then the judge will then reduce the damages by the percentage of fault. Now, there are some special comparative negligence rules out there. Some states follow what's called a pure comparative negligence scheme, which means even if the plaintiff is 99% at fault for the accident, the plaintiff can still recover its 1% that the defendant was at fault. Other states follow either a 50% rule or a 51% rule, which says that if a plaintiff is more than 50% responsible or at least 50% responsible, then the plaintiff cannot recover. And so one of the things that occurs in every jury trial that you will ever see on a negligence case is the defendant attorney will do the weighing of scales and says, if after you hear everything it comes out and they're both equally at fault, then give us 50% negligence. If it's in a state that doesn't allow for recovery in a 50% situation, then the defendant will win, even though they were 50% at fault. There's another old doctrine that still exists, but it directly conflicts with the concept of comparative negligence. That's called assumption of the risk. Assumption of the risk means the plaintiff knowingly and voluntarily accepted the risk of harm. And where we generally see assumption of the risk is in the contract sense. When you go to a baseball game, when you go to a football game, and you look at the terms and conditions of the ticket. You used to see it on a paper ticket. Now there's going to be a link on your electronic ticket. There will be in there some sort of waiver that if you trip and fall on the stairs at Boone Pickens Stadium, you have assumed the risk of walking up and down the stairs. You cannot sue the school, the OSU, simply because you tripped and fell. You have waived your right to recovery. Same thing if you go to a baseball game. Undoubtedly, there is some contractual waiver of risk of getting hit by a foul ball. If you get hit by a foul ball, the law will assume that you knew that there would be the risk of getting hit by a foul ball. And this is why stadiums provide areas that are screened off by a net with the idea that if you are concerned about getting hit by a foul ball, you will sit somewhere behind. So negligence is a big topic. We could go on for hours and hours, but I did just want to give you an overview of how it works. In conclusion, what did we learn today? Negligence is the failure to act reasonably, to do what a reasonable person would do in the same or similar circumstances. There are 5 elements of negligence. Make sure you know the elements, because that's an easy question to ask, and so probably will appear on your test somewhere. That's all for this one, and we will take up again with the next topic on product liability. Thanks for listening.